Ladies and gentlemen, please welcome Nicholas Mirzai.
Gee, that makes me sound very impressive. Thanks, Matt. I thought it would be interesting to, rather than bore you with cases that you could probably read yourselves if and when they become relevant, to speak to some of the circumstances which come across my desk and try and redact the names of the parties so that if they come across your desk, you know who to call, or maybe you can just answer the question yourself. But there are a number of circumstances which appear to be common. Lawyers are notoriously, I hope I'm not stepping in it here, but they're notoriously uncreative people who try and reinvent the wheel, and it's the same wheel, it's just over and over and over again. So the same problems arise several times, just under different heads, and I've tried to class them into particular categories for convenience, and there's no cookie cutter guide or advice to the client, but if you can diagnose, the idea is if you can diagnose these problems very early, there may be a resolution which is far more favourable than waiting until the fine people at Hall Chadwick are appointed and then it's all game over. So this legislation came into force in 2009, although it really came into force in 2012 because they couldn't get the register to work. They'll tell you it's because they were fine-tuning the legislation, but if you actually bother to read the thing, you'll realise it hasn't been fine-tuned at all. This is my copy of the book. It's very heavily used. There will be a new edition sometime in the distant future when I can get across all the new cases. The only other thing I'll say before I speak to some of the cases, and some of the cases which do not appear here, is if you have any questions, it's probably convenient if you just ask them throughout. You don't have to wait till the end, just raise your hand and I'll address your query. Otherwise, you'll probably forget by the end and people will want to go and have a drink, so just raise the question as and when appropriate. I don't intend to spend too much time on the jurisprudence here, mainly because you're all very highly educated people who can read. What the PowerPoint intends to provide is the ratio, the key part of the decision, which you may or may not know and you may or may not find useful, but as far as the factual matrix is concerned, every case is different, so treat the facts of the cases as things which may change. So some of the newer decisions which have come out either this year or last year, and there's one there which I haven't put on the slides, which is a matter that I appeared in, are the first three. The older cases tend to be not old law, but law that people readily appreciate now, with the White and Spires case being an interesting constitutional point. For my view, I think the PPS is, albeit a difficult thing to come to grips with, it's probably constitutionally valid, but I'm waiting to see something come before the High Court. The highest that we've seen so far is the Victorian Court of Appeal, and there have been two decisions in that court. What was Forge about? Forge was Justice Hammerschlag's decision about the $50 million turbines. Does anyone read a bit of press about that? They forgot to register. They said they didn't have to because it was a fixture, i.e. affixed to the land. And Justice Hammerschlag said, you've got to be joking, it's not a fixture. And also said that the lessor, who was Forge, was readily engaged in the course of leasing, so they didn't get to have any exception. The case is useful on that point. What do the words regularly engaged in the course of leasing mean? Does everyone know what I'm talking about? A PPS lease is a security interest. You have to comply with the Act. So if you haven't registered, then you get your powerful lawyers to say, oh, I'm not in the business of leasing. And then the judge says, yeah, you are. They tried to say that you had to be regularly engaged in the course of leasing in Australia, not that that was your business model anywhere else in the world, which of course fell on deaf ears. The judge said, well, no, you knew that you were a lessor and you did this, you're obliged to comply. Interestingly, in New Zealand, the cases, and I don't have the authority, but the cases say that the word regularly means more than once. So it's a very tight rope. I should have just said twice, I guess. Regularly means more than once, there you go. Although that's distinct from ordinary course of business, which is a very separate thing, and for that you probably look at the trade practices legislation, which isn't called that anymore, but it's mainly that line of authority. Gelpack was a case that I ran against my tutor at the bar, who inherited what I will call a dog of a brief, because if you read the decision, he lost on every ground, so it made me look like this sort of really good barrister when really it was just an easy case. The liquidator, so somebody from Hall Chadwick or some other liquidator, I can't remember, said you don't have a security, it's all invalid, and I applied under 1321 of the Corps Act to say, well, I think you're wrong respectfully for a number of reasons, and the judge said, yeah, look, I agree. And you can always tell when you've got a case which is strong because the judge won't reserve. He'll just hear argument and then give a decision immediately and just knock the other side out. So I said, oh, you're on a cost. He goes, yeah, sorry, have your costs, have your costs. It was great. It was, I had to run this 2 or 3 days before my wedding, so my now wife wasn't impressed, but she's my wife still, so it's fine. There's nothing really remarkable about this decision in terms of the authorities. The only thing that I will say is that it relates to what is the source of the security, and I think we've all had to face that question for anyone playing in this space at some stage. There seems to be this archaic practice which used to be very useful, where you used to include ROT terms, retention of title terms, on every invoice. So you send out an invoice and say, well, this invoice title is retained by the seller until the purchaser pays in full. That's a bad practice. Can you please, if you are in the business of doing that, stop doing that? Don't do that anymore. Instead, set up a master agreement, a master terms of trade, register your PIMSI immediately, and then say, if you just can't resist the urge to put terms on the invoice, if you just have to put something on there, just put this invoice is rendered subject to those terms. And that way, when the undesirable happens and the liquidator or VA is appointed, your client's protected, or you are protected, or the liquidator doesn't get to argue that you're not. So I'm just catering for all the different audiences in the room. But this was an example of a case where the client had in fact done that, so I relied on the 2012 terms and said, well, if they don't apply, then you go back to the 2007 terms, and if they don't apply, the invoices apply, and the judge said, I agree with you in all of them. It's very fact specific, and it links to the next case, which is the central cleaning case, which analyses a similar, the question being, what is the source of the security interest? And notwithstanding the fact that on appeal in this case and in the previous case, the court held that a security interest was validly created by the relevant document, I wouldn't be relying on that. I'd be trying as best as possible to get it right as early as possible and not have this fight at the end of the day, because even if you're right, it's expensive. And I can tell you in the gel pack case, I think they're still chasing money. So that's how that one unfolds. I don't want to speak very much about these older decisions because I've spoken about them a million times and they're pretty well known now, except to say that this decision is a very good one because it refers to this book very favourably. So have a look at this case on that particular point. I'll tell you something off the record. I was briefed when this matter was in Sydney, and the liquidators commenced proceedings in Victoria, and they said, oh, Sydney Council, Victorian bench, you shouldn't appear in that case. And then the judge referred to the book very favourably. So I said to my solicitors, wasn't that the worst mistake yet? And they lost. I said, that was a dumb decision. You should just keep me in all your cases. That's the basic point that I made. And even I think the primary judge got it right. This is a great case if you're ever concerned with the taking free provisions, which ironically enough I was concerned with today. I'm writing some advice about something or other, which I shouldn't speak too much about, but essentially the judge considered 3 distinct scenarios. One where there is a sale, but the purchaser hasn't picked up the goods yet, but they've paid in full. Well, the question is that a sale? Has title passed at that stage? 2 was the lay-by circumstance, so where they haven't paid in full, or they may have made no payment, but they've reserved the right to that asset. Well, is that a sale? And 3, where there's been part payment for the asset. And it's very interesting because the court said that the PPSA does not define when a sale occurs, and the judge was comfortable to refer to the sale of goods legislation, which varies in each state. So it may be unsatisfactory, but that appears to be the present position. For all intents and purposes, where there is part payment, there may not be a sale. So you can think of the poor person who's made a partial payment. They've paid some monies in, the company goes under, they lose their right to the asset, and they get a wonderful case to prove in the insolvency for the $500 they paid for a white good, for a company where they're going to probably see $5, a cent in a dollar, if that. So it's an interesting authority, and it will pop up more and more, I suspect. Dewar & Hugh was a wonderful case about a very creative appealing party, or at least their solicitors were very creative. It's a characterisation case, and it concerns, the facts are very dense. It's 100 and something paragraph judgment, so I'm going to try and summarise it in a satisfactory manner, but forgive me if I get something wrong. A party was involved in litigation, the cause of action of which is not important. The respondent to that action lost, and there was an award of $5–6 million in damages against the respondent. The respondent didn't like that and appealed. And the applicant did what all good applicants do and say, well, you're not worth the shirt on your back, I'm going to apply for security for costs. The respondent resisted, and anyway, there was a mini trial, and the court said, no, if you want to appeal, you've got to pay $1 million into court. Everyone following so far? The applicant's got to pay $1 million in. So the applicant says, okay, I'll do that, pays $1 million either into court or into a joint account, and immediately takes grants an ORPAP to a sister company and says, in repayment of some fudging loan, I don't think it was a legitimate loan at all, it may well have been, you take an all assets charge, the goal of which is to say, well, you are, the sister company then perfected that interest, and the goal, at least in theory, was to say at the end of the day that even if the respondent applicant on the motion was successful, they wouldn't be entitled to the monies because they held an unperfected interest as against the sister company's perfected interest. And the court had to analyse that, and the court really struggled because they said, well, yeah, that's what the Act says. And ended up saying, it was Justice Santamaria's judgment with which the court concurred. His Honour said that because the payment of monies into court is not a consensual transaction, it didn't create a security interest, so you're not having a fight between two PPS interests which are resolved by the Act, you're having a fight between the PPS interest from the sister company and some other interest, and so the applicant ended up prevailing. But I thought it took him about 100 paragraphs to get there, so I thought it was a very ambitious attempt from the solicitors who weren't in the end successful, but they probably got paid their fees and probably don't care anymore. All right, that's all the case law that's seemed to have emerged, which is worth speaking about, subject to one case which I'll come to, and that's the case that I've run relatively recently. And I can beat my chest about it because it was ex parte, so there was no contradictor. So we got what we needed. But what about the issues which arise in practice, which you never see cases on because commercial parties either settle or they take a deal or they take a haircut or something happens? I'm still finding that one of the biggest issues is the characterisation of interests. Lessors still can't come to grips with the fact that they're bound by this, and they don't go and see their solicitors, who then don't give them the advice to register. I'm sure that the solicitors are across it, which may be an erroneous assumption, but I'm sure they at least know what this Act is, but they're just not quarantining the problem, and it's particularly prevalent in the construction industry, where you have people who, and just posit this, I neither confirm nor deny whether or not this was an actual scenario I had to deal with. There's a company which supplies scaffolding. They supply scaffolding to company A for a project which is going to take, on any view, no more than 3 months. Okay, so they're going to, it's a weekly rental, they pay week to week, it's going to be done in 3 months, maybe there's a bit of delay, it'll be done in 14 weeks, maybe 4 months, okay? But it's always envisaged to be a very short-term lease. As a consequence, they don't include any term in their lease because it doesn't serve their interest to include a term. When I say a term, I mean a period of time. They're very happy to continue receiving rental monies the longer the lease goes. So they go, unless and until you give it back, and even when you give it back, if it comes back dirty, we're going to keep charging you. Wonderful business model. Except when it all goes to hell and the lessee goes under, they turn around and say, it's a short-term lease, we didn't have to register anything. But is it? There's no term, there's no period. How do you know it's a short-term lease? Oh, the actual thing was meant to finish in 3. Well, sorry, is that a part of your agreement? It doesn't exist anywhere. The proper characterisation of that is that it's an indefinite lease. Not an indefinite lease as in one which goes forever, but it's a lease with no fixed term, which 13(1)(b) says is a PPS lease. And they never register, so 267 says, well, you're out. We'll keep your scaffolding. Not only do you not get your rental that you're owed, we'll keep your scaffolding. How much do you want to pay us to get it back? So I had a case where this was the exact scenario. There's a case called Docker Formworks where this actually went to trial and the lessor failed. I mean, the Act's pretty clear. But they briefed Silk and we all geared up and, oh, put our wigs on. We were all ready to rumble. And a day before the actual hearing, they said, well, we won't prove in the insolvency and we'll pay you a small sum of money. And then we didn't quibble about the law anymore, we just quibbled about the number. And that's how it ended up transpiring. But it's a very unfortunate consequence because normally a creditor in insolvency will need to take a hit on what they're owed, the rental, right? They'll have to take a haircut on that, but they'll get their stuff back. Here, not only did they not get their stuff back and they didn't get their rental, they had to buy their stuff back. It was a pretty bad outcome, but of course the value of the item to them under fire sale conditions is still worth it. They still want to get the collateral back, so they do offer money, which the liquidator goes, delicious, I'll pay out all my lawyers and then go and chase the tax office for a preference or do something like that. Other issues which arise outside of characterisation, so leases is one example, but there are a myriad of transactions, and really there isn't a cookie cutter approach. The Act says you really have to look at the substance of the transaction and work out whether it gives rise to a security. The identity of the grantor and circumstances where the grantor changes is another huge area of concern, and it arises in a number of ways. Sometimes you have a structure where the companies are so large that you're not doing business with a company, you're doing business with a corporate group. The contracting company is company A, but the asset holding company is company B, and the expense company is company C, and they all sit under the head and there's subsidiaries left and right. And the real question that you should be asking as a creditor supplying to these entities is who is actually going to hold the collateral? Because if you're taking a security interest against an asset over somebody who doesn't hold the asset, well then when they all go under, you're not going to get the asset. You don't have a registration against the correct entity. And people say, oh, that's all right, if you've got serial number goods, it's fine. You just put the serial number in, you're fine. No, that's not the rule. The rule is, in a commercial context, you have to get the grantor right. It is uncompromising. And how do you identify a grantor? I'm not going to tell you. What must you do where you have a corporate grantor? Loud and proud. Say it loudly. ACN. You need to include the ACN. It is not sufficient to include the company name. It is not sufficient to include the ABN. Although I may argue opposite tomorrow. But under the Act, it's insufficient to do that. I reserve my position on the argument point. But the Act clearly says ACN, ACN. You go, okay, fine, ACN, I've got it, he said it, he wrote the bloody annotations, ACN. You then get a circumstance where the company is not acting in its own capacity anymore, it's acting as trustee for the discretionary trading trust. What do you have to register against then? Your silence is very encouraging. Not. Anyone know? The ABN of what? And? Correct. Correct. The ABN of the trust. Why do you have to register? I've always found this fascinating. Why on earth would you have to register your proprietary property security interest against something which cannot, as a matter of law, own property? A trust is a fiction. It doesn't exist. We made it up. It doesn't have a separate legal personality. The reason why you have to do it is because the Act says so. That's it. You just have to do it. And if you don't do it, you'll be sued or some liquidator will come in and say, 267, you didn't comply. And I probably drafted that letter.
What section is that?
That says you have to register against it's a section of the regs. So 153 of the Act says you have to register against the correct grantor's details. Grantor's details. And the regs, I think it's clause 1.4 of Schedule 1. Oh, how intuitive. It's a mess, but you've got to navigate through, which says you have to register against the ABN of a trust. And then you say, okay, but they're not the ones holding property. So I'll register against the ABN of the trust and the ACN of the corporate trustee. Okay, I must be bulletproof now. What happens if the asset against the terms of the contract is misappropriated and given to a third party? So you don't allow this, right? The contract says, under no circumstances can you sublease, subhire, sublet, misappropriate, give, part with, bestow, assign, all of that. Okay? And then it happens anyway. Well, you've got to look very closely at section 34, which says you've got 5 business days of when you get knowledge of this transfer to register your interest against the transferee, the person who actually has the asset. It's awfully onerous, especially when your item is not something you can whack a GPS tracker on. I mean, how the hell do you know where it is? Or how do you know if it's moving between a corporate group? I don't have the answers. I didn't write the legislation. But I can tell you it's creating a raft of problems. So identifying the grantor is a very, very difficult thing. Prima facie, policing that is an increasingly difficult thing. Okay? Other circumstances where it creates a bit of a problem is where the asset that you're dealing with isn't a fixed asset. What am I talking about? I'm talking about cash in your pocket, legal tender, fungibles, things which you don't actually own. You don't own the $100 note, you just own the value. Now, what about grain sitting in a silo? Well, if I deposit a ton of grain into a silo, am I entitled as a matter of law to get that exact ton back? No, that's not how it works. You get the equivalent grade ton back. How can you take a security interest over something which changes? Well, there are a number of very interesting rules. Another scenario which creates some difficulty and which has some unresolved outcomes is the storer's scenario. What am I talking about? I'm talking about storage houses, right? Posit this, and I'll make it personal to scare you all. You've got $50,000 worth of assets and you're moving house. You take your assets to Kennard Storage and you put them there. Kennard Storage says you will pay a weekly rental fee of $1,000. You may have some very expensive assets, unless and until you pick them up. You go, okay, fine. You sign the agreement, you pay your whatever deposit, and you walk away. Tomorrow you pick up the newspaper and Kennard's is in administration. And the administrator says, you've bailed goods to Kennard's. That's a PPS lease for the purposes of the PPSA. You didn't register. Thanks for your stuff. And what do you do? What do you do? We're all lost. You go, oh, I'm not regularly engaged. Okay, you moved house twice. Now you're engaged, regularly engaged. What do? You pay the storage fees and you pay the extortion tax. Yeah, you do all of that. But as a matter of law, you're in a little bit of trouble because chances are, it's not just a lease, it's a bailment, and chances are that is a bailment. Bailment, as a matter of law, means the conferral of possession with no more. Fascinating, isn't it? I'm yet to try one of these cases, not worth enough. The case that I have tried is when a storage house storing grain faced significant difficulties, and instead of talking about $50,000 worth of personal effects and chattels, we're talking about $9 million worth of grain. And they wanted to have the fight. They're like, you roll the dice, Mirzai, go ahead. You roll, keep rolling. Anyway, I think that settled because the grain supplier had a stronghold on the AllPap holder and said, you better release us or we will move a lot more business abroad. So not really a legal outcome, but a commercial one. I got paid, it's fine, it's all. As long as I get paid, it's fine. What are some other issues? Registration defects take the cake in terms of errors that are made, human errors, human-controlled errors, and I've mentioned a couple of them, registering against the ABN when it should be ACN, or ACN when it should be ABN, or getting a digit wrong, or doing any sort of mess up. If I can give you some advice, if you're the people that are doing the registrations, try and get somebody really junior to do the registration, because it's a menial task, and then get somebody who you could actually shirt front in the lobby to check the registrations and make sure they're checking them meticulously. So have two different people doing it just to quarantine and catch any errors. There are a few firms around town, legal firms, who refuse to do registrations for this reason. They'll check them, but they won't perform them. Did you know that ticking the transitional box for a non-transitional security interest is a fatal defect? Why does the transitional box still exist? Why is it still there? That's rhetorical, I don't know. I don't know why it's still there. It should be gone. There's no transitional security interests anymore. They're gone. But it's still there. And if you tick it, 337 capital A says it's fatal. Unless I can convince the court in a case that I'm running that it's not. But that's neither here nor there. The same thing happens for the PIMSI box. Everyone goes, oh, PIMSI. You know what PIMSI is? Is anyone familiar with what a PIMSI is? Put your hand up if you know what a PIMSI is. Not enough people. It's a purchase money security interest. What's a purchase money? That's really helpful, thanks. What's a purchase money security interest? A purchase money security interest is an interest which takes super priority and it's preserved for specific circumstances. Because you obtain a priority position by registering, okay, that's how you obtain priority under the PPS. If some all assets charge, or all PAP as we call them under this regime, is taken over a company and you're an innocent little supplier who wants to supply assets, well, how can you ever beat the registration of the all PAP holder? You can't. So what you do is you take a PIMSI, and it's reserved for people who provide new collateral to the company. So a lessor giving new property, or a retention of title supplier supplying new property. They register a PIMSI. But lawyers, being the clever creatures that we are, we go, oh, super priority, everything's a PIMSI. Woohoo! And you just go tick the PIMSI box for everything. The problem is, if you say it's a PIMSI and it's not only does your interest get de-elevated from priority status to normal status, it's invalid. It's as though it was never there. So you have to get it right. How do you know? Well, if you're not sure, why don't you register twice? That would be a really good idea. Do the PIMSI and the non-PIMSI.
Nick, does that include a sale and leaseback transaction now?
No.
That was one of the proposals, though, wasn't it?
No, sale and leaseback transactions are out because you're not adding new value. If you sell something to someone and they lease it back to you, you always had it, so the AllPap always attached. You don't need that exception. I think it just doesn't fit within the definition, but let's not get into the jurisprudence on that. Other errors outside of the binary tick box, not tick box, are the use of numbers. And timing errors. So it's not just you need to register in a timely fashion. You need to make sure your interests are on the PPSR. What's the rule? The old company charge rule. What was the old company charge rule? It's too late in the day, isn't it? You shouldn't be getting quizzed. 45 days, sorry, yes. And under the new PPSA, you have 20 business days. And everyone goes, okay, 20 business days. But that's not actually strictly correct. It's 20 business days to survive against the insolvency practitioner. But if you have a PIMSI, and it's an inventory PIMSI, it's before you supply the collateral, okay? So my view and my advice generally is don't worry about it if it's too hard. Just make sure you've got your registrations and your documents tight before you send the first batch of goods, okay? That's the advice that I've been giving to people to tell their clients, all right? And that way you avoid all of these difficulties. If you fall outside of these times, if you don't register at all, the PPSA says you're done, 267. If you fall outside of these times, so you get a new brief, you get some new instructions and the client has a security interest which they haven't registered, what you do is you either register again or you go off to court and seek an extension of time, and then you've got to do a commerciality test. You know, if it's worth 10 grand and you're going to spend 10 grand running off to court, probably not worth it. But if it's worth $1 million or 100,000 or whatever the client thinks is commercial, then you may want to do it, okay? And if there are a huge number of these errors and you need to do a number of these registrations, you can do them all in one application to save some money, which is what we did in this other case, which I'll come to. Right? And of course, number 4 is the deemed security interest, which I've already spoken about. When you think you're not a security, but you are, and the far more benign error, which is where you think you're a security, but you're not, I'd rather you be in that category where you think the PPSA applies, you spend $7 registering something, and then it turns out it doesn't apply because the consequence is 0. The reverse consequence is you lose your asset, so it's a far more sinister outcome. I was mentioning a little while earlier about what the PIMSI is. Here's the legislation which links to that. So section 14 describes what it is. If you don't know, just make a note, or you've already got my notes, so just section 14. But the priority is actually conferred by section 62. So people just read 14 and go, okay, we have a PIMSI, we'll tick the box. You've got to comply with the timing requirements. It's not just about complying, it's about complying with the timing requirements as well. So make sure you have a look at 62 and advise the client accordingly. Here's what 337A says. This is a very, very draconian outcome. Ticking the transitional box is a very, very easy mistake to make. You click on the screen and it just ticks the box. So this is a very draconian outcome for, well, arguably the whole PPS for leases is draconian, but this is a particularly draconian result because it creates an arguable fatal defect. And because the reason why it's potentially fatal is because the words without limiting 164, which is what usually describes a fatal defect, this section arguably amplifies 164 without limiting it. So that's the scenario that we're dealing with. Now, what are the fights that normally occur? Normally you don't get too many fights, at least in my experience, between a perfected interest and an unperfected interest, or between two banks, two secured creditors. Normally there's a big fight between a secured or a purportedly secured creditor and an external administrator. So it's normally when a liquidator, administrator, receiver, trustee, someone in that capacity comes along and really looks at this for the first time. I call that sort of position a quasi-judge's position because they get the first crack, they get the first determination about what the security is, and whatever they say goes unless you challenge it. So really, furnishing, if you're a creditor, furnishing the insolvency practitioner with as much information as possible when they ask for it is probably a very good idea. Of course, if you don't have the information, you can't create it, so you have to be a little bit careful. I've already discussed the distinction between 267 and 588FL. If there's no registration, you look at 267 of the PPSA. If there is a registration, but it's out of time, you look at 588FL. They have the same outcome, but for whatever reason, you can't extend time if you don't have a registration. What are you going to extend the time over? It doesn't exist. So you can only extend time if there is a registration, which is out of time. Okay. Now I've got my bee in a bonnet about point 3 under the heading vesting provisions, which says under the old chapter 2K, you could extend time to register your security interest, which used to be called a charge, even after the appointment of an external administrator. Okay, so you could come along afterwards and say, whoops, we forgot. Can we can I just extend time please, pretty please court? And you have to say pretty please because it's discretionary. And then the judge goes, yes, all right, you can have an extension. Under the new legislation, it says the provision which bites if you don't register on time doesn't say that the security interest is void against the liquidator. It says that the property vests in the grantor. That may mean very little or it may mean a lot. In my view, if something vests in the grantor, then when you come along later and try and extend time, the question is extend time of what? It doesn't exist. It has vested. It is gone. So unless the court is bestowed with the power to unvest or reconvey the security, the court does not have any power to do this at all. And yet there are about 3 or 4 cases where it's happened, which annoys me. Because I've got a case at the moment where I'm like, if a creditor can do this every time, then an administrator can never make a call. They're going to burn creditor money saying you don't have a security and then face this argument inevitably. I mean, you either have primacy of the register or you don't. I'm not going to convert the believers, but I need to convert the non-believers on the bench, which I will do when one of my matters comes before. This matter will not settle. 99.9% of my matters settle, but this matter will not settle. So that's something to think about. Of course, if I ever get a creditor in that position, I'll serve my 588FM application because you have to try. You've got to do something. Usually it's worth 7 or 8 figures by the time it all gets hot, so you need to do something. Okay? Other questions include who is entitled to reasonable realisation costs. If you're a party who goes off and sells a security which is subject, sells property which is subject to a security interest, because the administration is boring and you want to get some fees or you want to do something or you think you're entitled to do it and it turns out you're not, are you entitled to your realisation costs or is the secured creditor? These are issues which are at present unresolved by the PPS, but they're interesting issues. Normally the creditor and the external administrator at that stage have spent so much money that they just want to get along. So I've written a paper about all this, the vesting and void point, and I wrote it a long time ago, 2013. It's in the now ARETA journal. Fascinating. That's the provision which bites. It's particularly pertinent for today's talk given the audience and where we are, that we talk about the vesting rules. One thing which hasn't been considered other than in the authority which is up there, which is the other case that I said that I would speak about and where I was led by Mr. Bernard Coles of Queen's Counsel, one of the only Queen's Counsel which remains in this state, is not only do you have to extend time to register your interest under 588FM, but if you're seeking to extend the time to register a PIMSI, you also have to extend the priority provision, because if you just extend time to register, it doesn't undo the fact that you're in default of Section 62. So you may have your security interest valid against a liquidator, but it may not mean anything because some ALPAP holder is going to take the whole asset anyway. And the judge was really perturbed by my attempts to squeeze this in because we did it ex parte and all of the relevant ALPAP holders didn't have a right to be heard on the application, and he was really concerned about this. I said, it doesn't matter, they don't care about PIMSIs, just give us our order. And with a bit of kicking and screaming, we ended up getting over the line. But that's not every case, so just be careful about that. The second part of the slide interestingly notes that this extension of time to register a PIMSI doesn't apply to inventory PIMSIs. It only applies to PIMSIs which are for equipment, not inventory. Don't ask me why, I think that's a stupid rule. In fact, I've written a paper about why it's stupid, but that's the position. That's the position at present, so that's when it applies. So there are a number of decisions that have applied the opposite of what I just said. You come along after the event and extend time, and here they are. The one to read, if you're going to read any of them, well actually you should read 2 of them, but judging by the first line and noting that the square brackets 217 is actually paragraph 217 of the judgment, it's a very long judgment, maybe just read Appleyard. If you ever want to do this, read the last decision, because that's the decision where Brereton basically considers all the authority up to this point. Or better yet, don't read it and just come to me, it's better. Just come to me, I'll do it. I already know what these cases say. All right? But there are a number of examples where the law is being applied in a skewed way. Another fascinating thing which I've come across in PPSA, quasi-PPSA jurisprudence, which remains unresolved, is the use of the word unsecured debt under the preference regime. Are we all aware of what preferences are? Unfair preferences? Do we all know what insolvency is? The liquidator has the power to claw back monies within 6 months. But it only applies in relation to unsecured debt. The question, which I have for you all, is does unsecured debt actually mean unperfected debt? So if you've got a security interest, which is unperfected, that doesn't necessarily mean you're unsecured. So if that interest vests sometime later, you've got to think, well, when does it vest? 588FL says it vests immediately before the administrator was appointed. But of course, at the time you received all of your payments, the administrator wasn't appointed. You just got all your payments. So you turn around to the administrator, the liquidator now, who's pursuing you under a 588FA claim and say, I'm a secured creditor. And on the face of the legislation, you're immune. That's a complete answer to the liquidator's claim. Is that facetious? Should I be telling you that? Well, it's in the legislation. You probably could have found it anyway. Now, that really needs to be resolved. I think that that's just a legislative slip, but it's there, it appears. There is another legislative slip amongst 400 million legislative slips. But if you have a look at 588FN, and it's not on the slides, you'll see that it refers to a circumstance under the PPSA which has been repealed. And it's still there in all of its glory. And you just go, wow, it's really easy to Control F and find that section and remove all references to it, but it hasn't been done. The legislature's too busy. All right, so who are the people who want to have a punt in this? I found initially when I first came to the bar, which seems like a short time ago, but it was actually a while ago now, that people were very skittish. Nobody wanted to have a fight about this because you have to think, who are the usual creditors who have a stake worth enough to have a fight? And they were usually banks who wanted to press on one side, but of course had committed the same error in 500 other cases. So they went, oh, maybe we shouldn't press so hard and settle cases. And nobody really wanted to have a stoush, which is indicative of the low number of decided cases, but I've seen at least 100 cases that have settled squarely on PPS issues, and I'm not the only person around town who deals with them, although I wish I was. It would be a great little niche. There are heaps of cases on all of these interesting points which don't go the distance, they don't go the whole way, because this legislation is really all or nothing. You either get the asset and you win and you get a cost order and you woohoo, have a party, or you lose and you lose everything and you have to pay a cost order and it's miserable. So nobody really wants to roll the dice. If you're facing a company in liquidation, you're already taking a bit of a hit. So as a creditor, sometimes you just cut your losses and say, well, I'll just deal with it. That's changing. And I'm not sure if it's changing because the numbers in play are bigger and people have to have the punt because they're liable to shareholders and they've just got to try everything. But there are a few cases which are really geared to trial, and the old settlement tactics don't work. I used to just wave the book around, walk into a room and go, oh, you don't know what you're talking about, here it is. And it used to be super effective. It's not working anymore. People are really reading this stuff and it's causing a great deal of havoc for my practice, but it's also resulting in cases being pushed further. They're not settling at mediation. People aren't taking their haircut. They want to see an outcome because they're so sick of being hit by this time and time again that they deal with it. Another thing which would be useful for clients, if there are any clients in the room, and when I say clients, I mean not liquidators, not lawyers, just clients, is don't wait for one of these circumstances to bite you. Spend a little bit of money correcting your security agreements and your terms of trade, because that money is extremely well spent. No matter how many times I say that, nobody ever pays attention, and then I get two briefs. One is a phone call saying, urgent advice, you need to get us out of this. And then when it does, and then you do whatever you can, and sometimes you can, sometimes you can't. And then the dust settles, and then you get a call, oh, how do we prevent this from happening again? And it's always the reverse. It should be the other way. It should be, how do we not have the stoush and then we don't have to pay you for urgent advice? But that doesn't happen. That's great for my practice. I love it. Keep bringing me the urgent cases, that's fine. But in terms of actually having a good business model, it would be far better to really look at this quite squarely. It's not like other changes to the law where you can just sort of, oh, I'll fudge it, I'll just get by. I've got title, I win. This really does change things. If you're not familiar with that, perhaps have a close look, or get somebody to have a close look at some of the cases referred to, at least in these slides. So the little incentive to have, the fight is falling away. That's point one. And I've already mentioned the circumstances in points 2 and 3. The other thing which makes these fights unattractive is that they're often subject to interpretation. So you want to convince a judge that a contract says a certain thing and that a statute says a certain thing, which is, the maxim is reasonable minds may differ. So you don't want to put all your eggs in one basket, and sometimes I've had cases where both sides won't tell me who they are. They brief lawyers or instruct lawyers who brief me and say, just work it out. Just tell us what you think the outcome is and we'll live with whatever the outcome is. So I'm like the quasi decision maker. And I don't know if they do live with it. I certainly can't bind them to that determination. But the advice is something like a joint advice. And it's not just me, it's something that Silk get to do very often. But it's a way to try and mitigate against the cost of litigation, and it's an option which remains on the table. So how do you deal with this conundrum which we face, which is the messy legislation? For all of you waiting for the Whittaker Review to produce revolutionary outcomes, keep waiting, just keep waiting. It's about 700 and something pages, which I'm sure the legislature is reading avidly, and they're going to adopt all those changes. I don't think the PPSA is going to change very much, unfortunately. I'd really like them to have a close look at the subleasing problem. The fact that the assets moving on creates a real problem for registrations, but I think it's one of those problems which is in the too hard basket. I can't think of a way around it, frankly. But if you're in the position where you're just living with the legislation, I think that it's sensible to say that you should get advice as early as possible and consider all of the competing interests involved, so not just your client's interests, but the other players and what their sentiment would be. Sometimes there are ways to have a fight without having a fight, especially if other people want to play ball. Something to consider. Again, spending money up front by getting 588 FM orders to try and mitigate against potential errors. It's like dealing with a cancer. You don't wait for it to become a big problem. If you can, you try and nip it in the bud. Otherwise, it becomes a very serious thing. Very, very similar under the PPS. It's often quite fatal to the outcome. If steps can be taken before the external administration comes into play, well, usually most of the provisions go live upon the event of default. So if you can get in early, that is advisable. And of course, proactive steps are better than reactive steps. Resources. This will be good for at least 6 months, a year. The book, that is, not the Act. I'm going to work on a new edition, but I haven't really turned my mind to it. So if you haven't got a copy and you're involved in this space, you're welcome to use it. Ostley has the Act if all you want is the Act. So don't use Ostley though, it's not the authoritative guide. The Reporter is an online service, a little bit more expensive, but if everything that I've just said, other than you need to register, hasn't sunk in because you don't deal with this very often, I think that the nutshell guides, which are the last 3 points, are very useful. They're what I like to call plain reads. You can read them from a flight from here to Brisbane, Perth, whatever. And they tell you in a nutshell way, conceptually, what this Act is designed to do. And once you've got the overarching rationale in your mind, the provisions don't seem so draconian. And I think the reality is, even if you think this is all horrible, you have to get used to it because it's the law that applies. Questions. I've invited them throughout, but you've all been very polite and not asked me anything. I just speak so clearly that everything is just crystal and it all makes sense and there's no queries.
Nick, that 20 business days, does that exclude the Wednesdays?
There's an argument from a certain practitioner that because the register goes down for 3 seconds or whatever it is, that day is not included. I would really love to see that argument run because I think it's not a good one. But I reserve my position in case I have to rely on it.